All right, that seems good enough for now. Welcome everyone. Hope you had a nice holiday weekend. We took last week off, so if you're looking for the recording of last week, it didn't happen. So we have several questions today that rolled over. As a reminder, this is not legal advice, it's just general information. So if you're looking for general legal advice, contact your association attorney. If you don't have one, maybe start looking. Please keep yourself on mute. You can unmute to ask a question or raise your hand or put your question in the chat, which just lit up because Chelsea put some instructions. So if you didn't know where it was, it's down there. And just remember the chat is intended for questions only or requests for clarification. It's not for legal advice. And then there were some changes that just became effective last month from in WUCIOA. If you have changes you'd like to see made to the community association statutes, primarily WUCIOA, you can submit them to the WSCAI Legislative Action Committee. The committee is looking to propose some changes during the upcoming legislative session, which starts in early 2027. So anything you're upset about or don't like, you can send, and the Legislative Action Committee will try and put those before the legislature. And with that, we do have a good bit of questions, but they may go quickly. So feel free to put more in the chat. And with that, I will give it to you, Ken.
Okay, well, I'll offer or suggest two of the things which took effect last month in the state law, which some owners and association may care about. One is that the threshold requiring a CPA audit under WUCIOA was raised. So it used to be if you had an annual budget $50,000 or more, you had to get a CPA audit, and that number was revised to $100,000 or more. We still have a lot of clients complaining about that, but at least it is some relief for smaller communities. And then the second is that there's a new requirement that if an owner submits a question by certified mail to the association, that there's a requirement to provide a substantive answer, and they define what substantive means within 30 days, unless you have a need to hire an attorney or expert to answer the question for you. So those are things to sort of watch out for, because we've already seen some clients where the owners are weaponizing the new statute to make demands of the association. That second one is, I think it's EHB 1501 for Extended House Bill 1501. These don't have RCW numbers yet because they're too new. Usually that comes around August. So question one, an association we manage would like to charge back owners for most operational and some reserve item expenses, in addition to the monthly assessments. For example, once an insurance invoice is received, the cost will be divided by the number of units and billed to the owners. This would also be a common process for maintenance and repair costs, including reserve maintenance items, annual backflow prevention testing, etc. Is this method of billing allowed under WUCIOA? Should expenses being charged back to owners be treated as special assessments? Do any other compliance considerations come to mind in considering this billing method? So the short answer is that unless your governing documents already explicitly provide for assessing in that way, WUCIOA will not allow it. So the change from the HOA Act or the Condo Act to WUCIOA is not going to change anything about how you can assess costs. So expenses can be assessed individually only as specifically provided in the CC&Rs. So if your insurance deductible can be assessed under the CC&Rs to the individual owners, then yes, you can do it under WUCIOA. You can do it under your current statute. But if it's not specifically provided for, even though it's allowed under WUCIOA, you can't do it. So absent a review of the individual community documents for any one association, it is not possible for us to answer the question about what you can and cannot assess individually. One exception is that WUCIOA does sweep in an ability to assess costs to an owner for misconduct, and that doesn't seem to be required in the declaration. But misconduct requires some sort of affirmative act. It's not just negligence. And so you'd probably need to consult with an attorney before you could decide whether an expense could be charged back to an owner under the misconduct provision. So my initial thought to this question was that if you have to ask if you can assess the cost individually, and it's a change from your past practice, that you can't do it without amending your declaration. Any thoughts on that, Katie?
That is under WUCIOA, keep in mind that pretty much all charges to the owner, except like regular assessments, will need to be given notice and an opportunity to be heard. So even if you have the ability to assess the deductible under your current documents, once WUCIOA becomes effective, you're going to need to give a little more notice before you just automatically put it on the ledger.
Good
All
point.
right. Our next question is, do you recommend boards have a code of conduct / ethics? And if so, do you have a favorite or a particular one you use? Is it recommended that the code has a signature line for each board member to sign? So we do like code of conducts. National CAI has one. We put one in our new bylaws that we draft. The challenge is that there is virtually no enforcement mechanism with any of these code of conducts. The board can't discipline a board member who violates the code of conduct. The owners can remove a board member by a vote at a meeting, but removal for violating the code of conduct is not automatic. And if your bylaws don't allow for it, then again, you can only remove a board member with a vote of the owners. So basically, getting signatures from the board members is more symbolic than anything else. It does help guide how board members should act, but it doesn't really have any teeth. Ken, do you want to add anything?
Yeah, the only standard in the statutes is that the board members act with reasonable care in what they believe is in the best interest of the association, and that doesn't really address their conduct so much. And again, there's no real enforcement mechanism for the code or the standard of care for board members either. So, third question is, when a board member has acted inappropriately towards other board members, and they're listing yelling, name calling, and more, what actions do you recommend? So you can ask the board member to behave. It is really, almost the limit of what you can do. If the conduct is disruptive to a meeting, the chair of the meeting does, at least theoretically, have the ability to give a warning to the board member that if their conduct continues, that they'll have to leave the meeting. And if it does continue, then you can ask them to leave or you can remove them from a Zoom meeting. And the ability to remove the board member is based on the ability to remove any disruptive owner from a meeting. But these are, I would say, rather extreme measures. And if you remove the board member, you may lose a quorum, which might mean you can't conduct business anyway. If you've got multiple people who are disrupting the meeting or treating people inappropriately, you can suspend the meeting and you can recall the meeting at a later date when people might agree to be more civil. You can also start a meeting with some kind of rules or a set of expectations for conduct from everybody. I ran a meeting last month where the first thing I did was told people that we were going to use Robert's rule where a board member did not get to speak more than twice on any matter, and they only got to speak the second time after all the other board members who wanted to speak had been given their chance, and to try and cut down on the number of times that individuals were responding and arguing with the other people during the course of the meeting. So, it is sort of related to the code of conduct. You can't enforce making people be nice. You can attempt to have a board member removed by the membership if you feel like it's really enough of a problem that you want to call a special meeting of the owners. But you may find that it's very challenging to get the required 67% of those in attendance at a meeting to vote to remove somebody. Often these board members who are, we'll say, difficult, have a small following of owners that they talk to and who will support them, which makes it almost impossible to remove them. Another thing you could consider is hiring a third party, a parliamentarian or an attorney to run your board meetings for you. And sometimes that will help. I do think that meetings that attorneys attend have better behaved board members. And I would add that sometimes if people know they are being recorded, they will behave better. So if you're doing a Zoom meeting and keeping a recording of it, it may cause some individuals to behave better. So you could also try counseling or, I'll say group therapy almost. I had a client where they had 5 board members and very difficult personalities. And after listening to them for an hour, because they were trying to force a change in how some of the board members conducted their business, my response was that they needed to decide how they could cooperatively learn to manage their community. And it's one of the first times I actually said they needed to consider hiring a facilitator or a team coach who could actually work with them to try and figure out if they had any shared values or common goals instead of trying to use the documents uh, to block each other doing what they were trying to accomplish. Any thoughts on that, Katie?
One follow-up question that we can just get out of the way now, which is, but what if I'm assuming the problematic board member was never voted on but appointed by the board due to a midterm vacancy? And it's not going to matter how the person became to be on the or came to be on the board regarding their removal or code of conduct. Basically, once they're on the board, to remove them, you either have to wait till the next election or the owners have to remove. The board doesn't just to get to kick someone off because they are now problematic and they had been appointed by the board. Unless, can you disagree?
No, I agree. Once they are appointed by the board, they have all the same privileges and rights as the other board members.
All right. Our next question is, I'd like to know if the new WUCIOA law related to meetings says that when a board meets to plan the agenda for our monthly board meeting, are those gatherings of the board open to homeowners as well? And then there's some discussion about calling it a working meeting and whatnot. So first, the new WUCIOA law regarding meetings does apply to everyone. So that started January 1st of this year. So this answer is applicable to everyone regarding working meetings, working sessions, open board meetings. We believe the legislative intent is that all meetings of the board are to be open. This would include any working meetings, even if it's just to plan the agenda or talk about the budget or anything else. So basically, when in doubt, all meetings are open. The board could determine that creating the agenda is a ministerial act that can be done over email with unanimous consent of the board members and therefore not have a working meeting to discuss it. You could do this by having a policy that says agendas are prepared by the president or the manager, and then approval of the agenda is a ministerial act. That way you don't have this working board meeting. But basically, anytime a board is getting together to discuss substantive materials or make decisions, which you could argue even creating the agenda and discussing what should be on it or not is a substantive discussion, then you would need an open board meeting or an open meeting for the owners. And that's just the safer option. The statute specifically says you can't call something a working session or have an incidental gathering to get around this open meeting requirement. So if you're having a meeting, have it be open. If no one shows up, great. Then you can just go about your business. Ken, do you have anything to add?
No, I think that works. I've had a couple clients who will have an agenda prepared by a manager or by the board president, and then that will be sent out for the board members and the owners to see. And then you could formally adopt the agenda at the beginning of the board meeting. There are a lot of certainly corporations that do that. And the board members then have a chance to revise the agenda at the beginning of the board meeting. But I think if you hold a meeting, it needs to be open. The next question, for an association to have two separate deductibles, does there need to be specific language in the declaration that allows the board to add a second deductible? I'll start by saying I don't know what a second deductible is. Does there also need to be language that allows the board to require an increase in certain owner unit insurance solely to cover the second deductible? Then the note says the primary deductible amount did not increase, only the deductible of a much higher second deductible. So I'm going to assume that rather than this being two different, a second deductible, there are higher deductibles for some kinds of losses. So we've certainly seen clients where a water loss will have a deductible of, say, $25,000 a unit, but the deductible under the fire policy is just a single $10,000 lump sum. So if that's the case, it's not that there's a second deductible, it's just the deductible for some losses is higher, and it would be treated exactly the same as the deductible is under your declaration. If you are allowed to assess the deductible under the declaration, you can assess, the one which you're incurring as an association. And the individual owners should purchase enough insurance to cover the higher deductible for the water loss. It's still usually a fraction of the value of the condo that they are insuring. We do recommend that you require owners to buy insurance, though many condo declarations do not require the owners to buy insurance, even if the deductible is being shifted to the owners for individual losses. So the requirement to pay the deductible, if it is in the declaration, is not dependent on whether the owner has insurance or whether the owner's insurance covers the loss. And a lot of associations and individual owners are surprised to learn that they have to pay for it even if they don't have coverage. But that is how the documents are generally written. So anything you want to add, Katie?
Thank you. So our next question is, how does the board ask members to leave the meeting after the 15-minute open session? What subjects qualify for closed executive session? What qualifies for subjects that should be open to the members? And how does the board address meeting minutes to include potential litigation against lot owners? So the first answer is, how do you ask members to leave after the open forum? You say the board will be going into executive session, and then you ask them to leave. Now, there are fewer things that qualify for executive session than a lot of people think. So unless your topic is going to fall into a category on the list that I'm about to read, then pretty much everything else is a subject that should be discussed in an open meeting in front of the owners. So RCW 6490-445 subsection 2 lists the specific topics that can be discussed in executive session. And they are to consult with the association's attorney regarding legal matters, discuss existing or potential litigation, mediation, arbitration, or administrative proceedings, discuss labor or personnel matters, discuss contracts, leases, or other transactions currently being negotiated, and to review bids. So if you already have the contract signed, it's no longer an executive session. and only if premature general knowledge of those matters would place the association at a disadvantage. And then the last one is to prevent public knowledge of a matter would basically violate the privacy of a person. So if someone submits a request for a reasonable accommodation, that can probably be discussed in executive session. That's it. Anything else you're talking about, if you want petunias or begonias, that's all in the open meeting with the owners. And the executive session is only to discuss that topic from the list, meaning you don't make the decision in executive session, you don't add more things, you discuss it, and then you re-enter the open meeting and the board votes to proceed with the lawsuit, to follow the attorney advice, to sign bid A. All of that happens back in the open meeting. So, reminder, it's clearly stated in the statute, no vote takes place during the executive session. If you have motions to make, those take place outside of executive session, and you invite the owners back in. If it's over Zoom, you can probably have some sort of breakout room that the board goes to, or just tell people to rejoin in 20 minutes when the discussion's over. Ken, do you have anything you want to add?
Yeah, just to clarify, the open session is not 15 minutes and then you get to excuse the members. The open meeting is the entire meeting unless you call an executive session. The 15 minutes is just the owner's opportunity to comment before the board can basically shut them up and conduct its business. So you can't ask people to leave. Next question. Is marijuana smoking on the premises legal? And then it seems to say that King County has some regulations. I am not aware of any regulations that King County has or even the state has about smoking on private property, whether it's cigarette smoke or marijuana smoke. You could certainly consult with an attorney to try and determine what you can and cannot regulate within your community. Most communities could regulate smoking, whether it's pot or cigarettes, on all of the common areas and maybe the limited common areas as well. Usually you don't have the ability to prohibit smoking within lots or within units, but it really depends on how extreme the conduct is of the person smoking. But yeah, the rules that apply to smoking within 25 feet of doors and windows on commercial buildings do not apply for condominiums and townhouses. Anything you want to add, Katie?
So next is, does the new WUCIOA allow for an HOA board to vote on a matter such as a homeowner modification request via email thread as long as, one, the board vote is unanimous, two, the email thread is saved, and three, it is placed on the next regular board meeting along with the email thread for memorializing and put into that meeting's minutes? The short answer is no. Unless the vote is for a ministerial action, something that the owners will ratify, or to implement a decision already made by the board, then the email thread will be insufficient and it needs to be at an open meeting. Now, we've said this before, but ministerial acts are not defined in the statute. So the board could consider adopting a definition of a ministerial action to make a procedure easier to follow. Clear policies that delegate authority for day-to-day operations may make things easier. We do recommend that any ministerial action taken outside of a board meeting be saved and recorded in the next open board meeting minutes, but it is unlikely that a modification request would be ministerial if there needs to be any sort of discussion on what will be allowed. So, for example, you could have a policy that owners, if they submit an application for they can paint their house one of three shades, whatever that may be. And then if it complies with that, that may be more ministerial. But if it's owner wants to install solar panels and there's some discussion on height or anything like that, that's not going to be appropriate for a ministerial act because there may be discussion by the board that needs to be done at an open board meeting. Ken, do you want to add anything or?
No, I just on that last point, if you have some fairly clear written standards for architectural changes, and maybe where you can put a heat pump in is a good example, then you can convert a decision into a ministerial act. Because if you have standards on where heat pumps can be installed and how loud they can be, and the application is in compliance with those standards, then I would say you're safe calling that a ministerial action, and the committee could do it by email. But if you have no standards and someone asks for a heat pump, then I don't think you can call it ministerial, even if it seems really straightforward. Next question. They're asking for general advice on conducting elections under the new WUCIOA requirements. So from my perspective, the only real change in the statutory requirements is that you now are required to use secret ballots for elections under WUCIOA, which was not the case under the HOA Act or Condo Acts. And that this is making it harder to prove to contestants who lose that the voting was done correctly and that they lost because the membership didn't elect them. I've had 2 times in the last month where people who lost in the elections were demanding to see every ballot and every proxy. And if you're under WUCIOA, you can't provide those without redacting out the information that would indicate how somebody voted. The other changes that a lot of clients and management companies are trying to do are changes which are not specifically addressed by WUCIOA, like how do you use electronic voting, or how do you sort of prove what the vote count was at the end, what kind of authentication or statement, who is the person who can certify the results of the vote. And those are not well addressed in WUCIOA or in the previous statutes. And I don't know that they're even well addressed in Robert's rules, because one of the assumptions is that the people who are counting the votes are being honest. And it's a little bit hard if their honesty is being challenged to prove that all they did was count the votes and report the results. So if you've got specific questions on a election you're trying to hold, or you're dealing with a very specific set of notices and timelines and procedures, whether electronic or by mail or in person, then you can certainly get legal assistance from an attorney. But I can't really give anything more general about how to conduct meetings. It's just not that much different under WUCIOA than it was before, and it's been a challenge under the previous statutes. Anything you want to add?
Oh, no, you covered it. We only have 2 more questions submitted in advance, so if you have more questions, you can put them in the chat. And our next one is, I'm trying to understand the difference between dues, assessments, reserve fund assessments, etc. Is there a formal definition so that they cannot be used interchangeably? So assessments is a broad term that includes any kind of payment owed by the owner to the association. Regular assessments are determined by the annual budget, and it will include a budgeted contribution to reserves. Fines and late fees are assessments as well. Special assessments can be for everyone or for some individual units. So there is a statutory definition of assessments in all of the statutes. Dues is used more as a shorthand and is just more colloquial. And then reserve fund assessments are, again, that budgeted part of your regular assessments. For collection purposes, they are all the same. Some require notice and an opportunity to be heard before they can be assessed. For example, fines. And remember, fines and fees are different, but they would both be considered assessments under the definition. Ken, do you want to add anything before I move to the next question?
No, I think you're good.
Right. We have been building up a reserve fund for future need without a formal reserve study. We do not know what a reserve study is. Will we have to give that money back? Can we still use it for its intended purpose? Does an HOA have to establish a separate bank account to track reserve funds? So just as a reminder, reserve funds are used for maintenance, repair, and replacement of reserve components. These are the components identified in the reserve study. The reserve funds are not used to obtain the reserve study. That money comes from your operating account. Under WUCIOA, the reserve account must be separate from the operating account and must be managed by the board. You do not need to return any money collected, regardless of what it's for. It is the beginning balance for your reserve study to determine future needs. So in general, remember, budgets are just a financial planning tool. They're not a set maintenance plan or anything. So you can move some money around. You don't need to give it back if it's not used for its intended purpose. Now, that being said, reserve funds do need to be used for reserve components. That's different than your operating account. Ken, anything to add?
A couple of minor things. The statute and WUCIOA applies to all communities regarding reserve studies right now. And in fact, it has since 2019. And so the statute defines what reserve components are and what are supposed to be in the reserve study. And just because the reserve study doesn't include it does not mean it may not be a reserve component that you would spend money on. So if the reserve study didn't include windows, but windows are a component the association is responsible for replacing, then you could still use the reserve funds for that expenditure. And then the other thing is you don't have to fund the reserve account. You're required at the budget time to tell all the owners what the reserve study has recommended for an annual contribution. You're required to tell all of the owners what their deficit or surplus is in reserves allocated to their unit, but you're not required to actually make anyone pay for reserve contributions. You know, that's you could wait and do special assessments when the repairs are needed. There's a push at the national level to require reserve funding because they don't want to see problems like the Surfside condominium collapse. And they think that was in part the result of owners declining to fund the repairs over an extended period of years. And I know there's pressure at the Washington state legislative level to try and force people to save money in their reserve accounts, which is basically forcing associations to raise dues in cases where a lot of owners are unwilling to do that. But it is, the reserve study is a required report you're supposed to have. The penalty for not having it, though, is that the owners can I think 20% of the owners can band together and demand that you include the reserve study in the next year's budget. And if that budget is ratified, then you have to do it. There's no other penalty for failing to have a reserve study. That's all I got.
Question from the chat is, what if the agenda is set by the executive board, president, VP, secretary, treasurer? Just those four set the agenda and send it to all members and the board, and then is there an opportunity to revise at the meeting? So I think this question needs a step back. So if the goal of this is to get around having an open meeting to make the agenda because you're just having the executive board meet to discuss and make the agenda, this would not work. So under WUCIOA and the open meeting requirements, you can have committees which this would be, an executive board is basically a committee, that can do things with board authority if they have at least two board members with exclusive decision-making authority, which I guess in this case could even be just the president and the vice president. But those meetings have to be open too. you can't form a subcommittee to exercise board authority, like setting the agenda, to get around having an open meeting of the board. So I don't think that you could have an executive board make the agenda, then send it out all to the board, to the rest of the board, and revise it at another meeting in a closed session. I think you could do that and still have that meeting be open, but I don't know if Ken, you have anything to add?
No, I agree. It starts to sound like an attempt to get around the open meeting requirement by calling it an executive committee. And the statute's very clear that the open meeting requirements apply to every committee that is exercising any board authority. And since we believe setting the agenda is exercising board authority, then if you're having that meeting, you'd still have to have an open comment period at the beginning of it and tell the membership when you're holding it.
Our next one is, can you clarify what the notice requirement will be to charge owners for individual expenses, assuming the CC&Rs do allow for that charge? Additionally, if part of our contract with the association allows us to charge the association a fee for each paper mailing we send, and the association opts to pass this fee to individual owners who did not opt into electronic communications, are there any compliance considerations that come to mind? The aim is for the association to be reimbursed for the cost of the fee. So the first part of the question is, I'm assuming, asking about the notice requirements under WUCIOA for an opportunity to be heard before charges are assessed, like for an insurance deductible. And for that, you're just going to follow your regular notice procedures, and you'd follow the notice and opportunity to be heard just like as you would a fine. So whatever that procedure is, if your documents require you give a hearing or the owner requests it, that's going to be dependent on your documents. We can't advise without looking at a lot more information about the association fees passed on for mailing. But I don't know if Ken, you want to add anything to that question.
Well, a couple things regarding billing owners to send a notice by mail. I think you can't do that. I think that there's a savings to the association for doing electronic notice. There may be a difference in the cost to the association for electronic notice versus mailing notice. And the contract between the management company and the association is different than the CC&Rs. And I believe that under the statute, the association is going to be required to send notice by U.S. mail, and it is a common expense. I don't believe that they can successfully survive a court challenge in assessing owners the cost of mailing them hard copies. They have a right to the hard copies. There has certainly been a trend of trying to assess more and more costs to individual owners. And we're seeing that happen in the management contracts a lot faster than we're seeing it happen in the governing documents. And so it might be possible to amend the governing documents to provide that specific fees are going to be assessed to individual owners, whether it's, oversight for insurance claims, or whether it's fees for sending late notices, or fees for, prepping the elevator for someone to use it to move in or out. Whether or not those can be assessed is all controlled by the CC&Rs or the declaration. And it doesn't really matter what the contract with the management company says. And even if the management contract were to say a cost can be assessed to the individual owner, in most cases, that won't be binding on the owner because the owner is not a party to management contract. If it's not in the CC&Rs or the condo declaration, then it is unlikely you'd be successful in assessing those costs. We also see a lot of costs which get assessed to owners and they just get paid without question. And so a lot of these things which end up in our office come in when a collections matter comes to us. And then the client's disappointed when we tell them we can't collect it because it's not provided for in their governing documents. And if their response is, but it's in the management contract, that really doesn't matter because the management contract is not what's giving us the authority to collect assessments. So it is a challenge if you're looking to, I guess, save money. You need to do it in a different way than just passing expenses that you normally incur onto individual owners. I'm reminded a little bit of the statute which changed this, I think it was this last year, that requires associations to have a payment method that does not have a fee associated with it. Because apparently some management companies or some associations were billing their owners a fee for the owner to make a payment. And so the statute got amended that requires the association have some method of receiving payment that does not cost the owner any money. And I don't know if that's mailing a check in or it's doing the ACH. They don't specify what the method is, but there has to be a way of owner paying their dues without incurring a fee. So I don't know if you've got other thoughts, Katie.
Our next question in the chat is, I believe, a follow-up to when we were discussing approval of ACC requests over email, which is the governing documents have a timeline to respond within 30 days. What is the best process going forward? So a few options. One, we have seen the document say the board has to respond within 30 days, and if they don't, it's automatically approved and stuff like that. So the first option would be you could just have on your monthly agenda, which would be within 30 days, that you just review all the ACC requests for that month. You could also call a special meeting with 14 days notice to review and discuss if you need to before your next regularly scheduled board meeting. If an acknowledgement is all that's required, then you could just acknowledge that the ACC request has been received and it will be discussed at the next board meeting. But it may make sense if your community has this timeline in your governing documents to adopt a policy for something that works for your community to best address how to handle these requests and have a board discussion within the timeline stated in the declaration. Ken, do you want to add anything?
Well, I have two thoughts. One is you could certainly set up a committee and delegate authority to the committee, and that committee could meet every 2 weeks if that was a way of making sure you could respond promptly. The other thing I would suggest is that you can, if you are not having a board meeting to discuss or approve the matter within 30 days, deny the request and tell them that it will be addressed at the next board meeting and what date that would be. The automatic approval only comes if it doesn't get denied. So you want to make sure that you have denied it within the 30 days or you have substantively addressed it and made approvals or approvals with modifications.
So our next question is, what is the process for borrowing funds from the reserves if the association has an unexpected legal expense and does not have any funds in its operating account to pay for regular operating expenses? So I don't know the statute number off the top of my head, but there is a process that allows the board to borrow money from reserves for unexpected or unintended, basically non-reserve expenses, if they provide notice to the owners and if they have a repayment plan that is sent out within 2 years or for repayment within 2 years unless it's unduly burdensome or they decide it's not in the best interest of the association. So basically that would be the process. You would send notice to the owners that you're going to borrow money from reserve funds and that the association plans to repay it reserves back by, I don't know, a special assessment within the next 3 years or 2 years. Sorry. Ken, do you want to
Yeah, so
elaborate?
there's not a requirement that you have given the notice in advance of the borrowing. There is not a requirement that you get a ratification from the membership for that borrowing. There's just a requirement that you tell the owners you've done it and that you essentially have a plan to reimburse the borrowed funds. And the reason for the plan to reimburse the borrowed funds is that you are going to increase the risk that the reserve fund is not going to be adequate. But I've also had almost every client that has borrowed money from their reserves simply declare that it would be unreasonably burdensome on the membership to try and repay it within 2 years because it means increase in the dues for the association. And I think it's actually reasonable to let the reserve study calculate what the new required contribution is, which may look like repaying the reserves, or if all of your upcoming expenses are several years out, it may just be a modest increase to make sure you have funds adequate when the funds are needed. It's
This
also,
next,
I'll offer the decision to do that should have been made in an open board meeting so that any owner who is paying attention to the board meetings would know in advance of the board doing it that they're going to borrow the funds from reserves.
and I'm going to read this next one and let you answer first. If you can tie a ballot to an owner, how is it secret? Challengers should be able to see all the ballots as there's no owner ballot link other than the ballots equal to the number of voters. So basically, how can you tie a ballot to an owner for the verification and then still keep it secret?
Well, what we have suggested is that the unit number and the name of the unit owner are redacted from the ballot. So the ballot might still show the percentage of ownership interest, and it would show who was voted for. And the statute WUCIOA, and this is still only a WUCIOA and only for WUCIOA communities, requires a secret ballot and requires that you withhold any information that could reveal how the person voted. So we have agreed with clients that if a person has given a proxy, who they assigned the proxy to is going to indicate who they voted for in the election. So we redact out the name of the proxy holder. So in that case, the proxy form would still include the unit number, name of the owner of the unit. It just wouldn't show who they showed the proxy to. And then the ballot, whether it was filled out by the proxy holder or the original owner, would have the unit name or the unit number and the name of the owner redacted out. And I can tell you because I'm living with it with a couple of associations that the losers in these elections are never happy. They want to see all of the full unredacted documents, and I believe that that is not allowed by the statute. Now, it might be if one of them were to sue in court, then we would ask a judge to view the unredacted documents in what they call in camera, which means that the judge gets to see the information, but the other opposing lawyer does not. And the judge then could determine whether or not the election results were correctly counted. We also do recommend that if there is a trusted third party, you could let that trusted third party do a audit of the ballots to confirm the results. I don't know if you've got anything you want to add.
Question is there an acceptable generic form to use for electronic communication slash notification opting in, which is not tied to an agency, or must we use the form provided by the current agency and update should we change management slash bookkeeping agencies? We'd like to avoid having to update these forms once individuals have opted in, like we've done 2 years in a row, even with the same agency. So I don't know what the management contract says with this question. The short answer is no, there's no specific form that needs to be used for opting into electronic notice under the statute. So basically, there's actually no form required. An owner could send an email to the board, to the manager, to someone who is in charge of notices that says, I opt in to receive notice electronically at this specific email. That's all that's required to opt in. There doesn't need to be an update. There doesn't need to be a check-in to see if they still want to receive notice by email or electronic means. That being said, if you want more people to receive notice electronically, the association can, whether through its management company or on its own, create a form that is sent out to the owners that do you opt in to receive notice electronically, and please put the email address if yes. So as a practical matter, if you change management companies, it may make sense to resend out that form or have a list that transfers to the new management company, just so you don't have to keep sending it out over and over again, but it's not required. And it does carry on unless you get bounce backs from a particular owner. I think it's 2 bounce backs. Then you have to start sending notice by mail again. Otherwise, there is no, unless an owner revokes it, there's no need to keep checking in. Ken, do you want to add anything to that?
Yeah, you need to have a record that the owner has agreed to accept electronic notification. If you change management companies and the records that prove they agreed to electronic notice don't come with you, then you'll have to get new records, whether those are new emails or new pieces of paper. And the other thing I'll mention is that when an owner opts in to receive electronic notice, that becomes the email, which is how the association communicates with the owner. And so when a request is made for the list of owners and the address with which the board communicates, that is going to include the email address, unless under WUCIOA, the owner has also requested that the email address be kept confidential. So that's something that we have started to add to forms that are requesting electronic notice, is that in order to help get more people to agree to electronic notice, we have put out a checkbox that they can request that the email be kept confidential so that every owner in the community does not get their email address when they ask for it. There is some controversy about this, but we do think that if you are using email for notice and an owner is asking for the contact information for all of the owners, which you are required to give them under the statute for free once each year, that you're going to have to give out the email addresses unless the owners have agreed or have asked that the email be kept confidential.
Well, question to that is there any notification required by statute which must be mailed by USPS once someone has opted in for electronic notification? Example, budget ratification, meeting results, election results, annual meeting materials, anything besides collection materials which require all forms of notification. So as this question suggests, basically your notices of delinquency will still need to be sent in accordance with the statute, which is by pretty sure certified paper mail. those cannot be sent electronically. Same with any foreclosure related notices. But other than that, once an owner opts in to receive notice from the association electronically, all notices can be sent electronically unless something would otherwise say no.
Yeah, my recommendation though is if you're doing something specific to one unit, like assessing a fine or trying to deal with enforcement issues, that you mail in addition to sending it, even if the owner has agreed to notice electronically, because the risk associated with them claiming they didn't get notice are high, and the ability to enforce is just increased if you can clearly demonstrate that you provided the notice required under your documents, and that's a lot easier with mail than email.
So, can an owner waive notice of electronic service if they just don't want to be bothered? So, an owner has to opt into electronic notice. If they don't want to be bothered, they don't have by a bunch of emails, they don't have to opt in. And then you still have to send everything via regular mail and paper. So they can't waive something that is an opt-in. I think that is the short answer to the question. Can you
I think
disagree?
the answer is no, just like they can't waive notice by mail either. You have to send it. So if they don't want the physical mail, they can opt in. If they don't want the email, they can refuse to give you an email address. Um, I know a lot of clients are wanting an email address for everybody, but there's no statute that requires an email address be provided.
And then we have one more question. And then if we didn't get to your question, it may be too specific for us to answer, or we might not have time. So it looks like there's at least one more, which is what are the personal service paperwork requirements regarding proof of service? Ken, do you want to
Well,
answer that?
it's going to depend on what you're trying to prove service of. So if it is related to an actual lawsuit, like a complaint, then the personal service is going to be from the person who is over 18 signing a sworn statement about when and where they delivered and to who they delivered the notice. If you were having a board member go door to door handing notices to people because you're allowed to do personal delivery, then you could simply have a written statement signed by the person who did the delivery saying who they gave the notices to. But leaving it in a mailbox doesn't count because you don't have, that's not personal service. Um, if it's something like trying to prove that you sent out the mail notice, then you'd usually have a statement from the manager that says, on this date, I placed all of these notices into the mail. You might include a copy of the mailing list of all of the addresses that you sent it to. If you were sending email as notice, then you could do the same thing. We don't see a lot of occasions where someone is asked to prove that they had sent the notice out or that they'd sent the notice out within the correct time. We see a lot of challenges where the notice was not sent within the correct time. And without anything else, we just advise the client usually to redo the notice and hold the vote or the meeting at least 14 days further out, even if it seems like they're duplicating the same efforts. Anything you have to add, Katie?
You covered it. Any other questions are too specific for us to answer today. So thank you all for joining us, and we will see you next week. Remember to submit your questions to info@condolaw.net for next week. Thank you.